Gentlemen, good afternoon. I am Andrew Ondari, and I'm here to discuss with you the concept of compliance and risk management in HR audit. This is a very important area because just like individuals in any country, we are all liable to all the legal requirements in terms of our behavior and actions. We are obligated to comply with the laws of the land, not only in HR, but also in relation to our environment. And because of that, we intend to address the various aspects related to compliance and what we can do as HR managers to ensure full compliance of the labor laws, our own policies, as well as industry standards. When we talk of risk and risk management, we are looking at elements in our processes, systems, and policies that can expose us as HR managers or as organizations to litigations and legal penalties. These are very expensive penalties, which we may not be able to pay, especially when we do not comply. So when we are talking of compliance, we are referring to three areas of compliance. One is the labor law compliance, two, policy compliance, and three, industry standards compliance. Non-compliance presents risks, and we shall be addressing ourselves to various types of risks, starting with financial risks, operational risks, strategic risks, as well as legal risk. So having said that, I want us to look at the content or scope of our topic. There are three key aspects that are covered in this topic. One is the compliance essentials in HR auditing, where we are looking at the various functions and aspects that we must comply with. Two is strategies for identifying and managing risks. So again, we shall expose ourselves to various methods of identifying risks, either through personal experience or the experience of others, or conducting research, or making observations for things that can be observed. And then for managing risks, we will be looking at the process, starting with risk identification, risk analysis, risk prioritization, risk implementation, and at the end, we shall look at the process of risk review, which means monitoring and evaluation of the effectiveness of our risk mitigation strategies. And then we shall look at risk assessment tools. These are either manual or technological tools that will help us to identify risks and how we can manage them. So these are the three key areas that we shall be discussing as we move on in this program this afternoon. By way of introduction, I've said that we operate in a dynamic environment, and for that reason, we must find ways of adapting to this environment. I have indicated that we operate in a complex legal environment. Why do I say it is complex? It is because of the intricacies and the interconnections between the various legal requirements and regulations, which can make it hard for many of us to understand or implement. An example is the interconnection between the three labor laws, namely, one, the Employment Act, two, Work Injuries and Benefits Act, and three, Occupational Safety and Health Act. Many of the provisions of these acts are interrelated. For instance, the Employment Act talks about safe working environment, which is also captured in the Occupational Safety and Health Act, and also is captured in the Work Injuries and Benefits Act. So it's upon us as HR managers to pick out the legal requirements in those three regulations and laws for purposes of developing policies, practices, and systems to ensure compliance. I have also talked about work safety, that all these legal requirements are related to work safety, diversity, data protection, and employee rights. Allow me to talk about workplace safety for purposes of understanding the element of compliance. That by and large, our employees and our assets must be protected at all times from damage or from harm. Employees need to be protected from injury, for example. Our assets like computers, buildings, and machines also need to be protected from damage or theft. Speaking of employee safety, this is covered under the Work Injuries and Benefits Act and OSHA, that we must put in place mechanisms to ensure that our employees are safe, meaning that they are protected from injury. We all know that injuries are expensive. Expensive because there is a lot of time wasted when employees are out there in the hospitals or their homes for treatment. Money is also spent because in some cases, our organizations pay a lot of money for treatment of employees who have been injured while they are at work. And also the time taken, that we take a lot of time when employees are either injured or healing and are away from work. This is expensive for any organization, especially if these conditions that brought about this safety concern could be preventable. On diversity, we are talking about engaging, utilizing, and protecting employees from different backgrounds. Diversity may include gender, age, ethnic background, or even nationality. That part of the Constitution and our employment policies require that we employ people from diverse backgrounds. The absence of diversity is discrimination. That some people may be left out because of their religious, ethnic, or educational background. Everybody should be given an opportunity to be employed when it comes to recruitment and selection, depending on the level. That failure to embrace this diversity may attract legal suits and attendant penalties if we are found guilty. So our laws, including our constitution, gives all of us the right to be employed and the right to be protected. On data protection, I believe all of us have been exposed to the Data Protection Act 2019. This act has several provisions on the role of data controllers. The data controllers are the organizations who have the custody of all data related to employment. And the Data Act requires that we protect personal data at all times. And this relates to confidential data related to the employees. I can mention a few of these areas that are protected. One is the salaries of the employees. Two is the family of the employees. Three is your health or medical status. And four is your telephone numbers, which should be protected. Why data protection? Because data can be used against an employee in terms of fraud. Take the example of your telephone, which is in the possession of wrong hands. So people can develop ID cards, they can create M-Pesa accounts and defraud others in your name. That is why we need to protect this data. We also need to protect data from exploitation. Certain data can be used to exploit the data subjects. Data subjects are people like employees. Data controllers are the organizations or departments. So we need to protect this data. If we don't protect, there are legal implications. For instance, administratively, if data is not protected by the data controllers, they run the risk of a fine of 5 million shillings or 1% of annual turnover. That can be very expensive. And this can be easily avoided if we protected our data. Secondly, if it's a criminal offense where a data controller gives out data which is protected, the penalty is 3 million shillings or 10 years jail term. So we are talking about compliance in terms of data protection because of the attendant implications. Speaking of employee rights, this is enshrined in our constitution, especially the Bill of Rights. In our employment relationship, all employees and the managers have rights. So we talk about employee rights related to one, recruitment and selection. Employees have a right to be selected to the organization for as long as they have the qualifications. That means that there should be no discrimination when it comes to hiring process. And therefore, employees have a right not to be discriminated. Secondly is the right to assemble or associate. In terms of employment relationship, employees have a right to join trade unions through which they can express themselves and also assemble. But for as long as this assembly does not affect the day-to-day operations of the employees. The other right is the right to leave, including annual leave and maternity or paternity leaves. So leave days are regulated, and as HR managers, we must always comply. So when we are conducting our audits, we will be looking at the employees' rights in various aspects related to human resource like recruitment and selection, training and development, compensation and rewards. I will be talking about this in a little while. I have said that an effective audit system helps to uncover non-compliance. By uncovering, we mean we discover or we identify areas in which we are not compliant. And this helps us in many ways. One, to review our strategies so that they are compliant. Two, to engage in practices that are compliant with the labor laws. And three, to develop systems, including data protection systems, to ensure compliance. So our HR audit helps us to discover those areas in which we are not compliant and taking corrective actions. And again, through an audit process, we also identify inconsistencies. Talking of inconsistencies, this relates to managers or organizations making different decisions for the same offense, for example, or for the same issue. Consistency helps us to be predictable. And one of the tools that can make us predictable is policy. So when we do a HR audit, we identify policies that are inconsistent with the realities of the day and take corrective actions. And again, HR audits helps us to identify vulnerabilities. Vulnerabilities are exposures to harm or damage, either to our reputation or to our systems or even to our data. What is it that can make us vulnerable or exposed? One is non-compliance. That means we are violating a legal requirement. Two is unacceptable or unethical behavior. That again exposes us to vulnerabilities. Then how are organizations vulnerable or exposed? One is the element of legal disputes. That this is a contestation or a disagreement between employers and employees or employees themselves. when there is a violation of a legal requirement. I can give a few examples of a legal dispute. One is unfair deductions from the salaries of employees. We all know that salaries are protected by the Employment Act, which says that employees should be paid in a manner agreed at the right place and the right amounts. That if an employer deducts certain amounts which are not covered in the law, then that becomes a legal dispute. And an employee can go to court and contest the deductions. Other disputes relate to personal differences like harassment. Under the Employment Act, harassment is a criminal offense, whether overt or covert. And an employee has a right to petition higher authorities. And if he or she is not satisfied, can go to the courts of law and sue the employee who is harassing them. And this has other implications like the employer's brand or reputation. So we must guard against legal disputes when we are conducting our activities, be they related to recruitment, training, performance appraisal, discipline, or even data protection, as I have mentioned. The other consequence of not complying with the law is financial penalties. These are in the form of compensations or fines that employees have to pay for violating a legal requirement. As I have indicated in relation to data protection, an employer who is non-compliant, which is an administrative offense, is liable to a fine of 5 million shillings or 1% of gross turnover. Those are financial penalties that we should easily avoid if we audit our HR systems, particularly related to data protection. Other penalties, like I mentioned, is compensation of the employees for reputational damage. Some employees may go to court and seek compensation for damaging their reputation. For instance, an employee is implicated for committing a serious offense, which is like theft, and he or she is dismissed. If they go to court and the court finds that they did not commit the offense, the court may force the organization to compensate the employee for the loss he or she has incurred when she was not in employment, or can require an organization to reinstate the employee and pay him or her all the salaries and the benefits for the time they were away from the office due to unfair dismissal. So again, compliance is key because we want to avoid those financial penalties. The other consequence is reputational damage. We all have an image to defend, both at the individual and organizational level. At the individual level, we have struggled over a long time to build for ourselves a good name, both for our families and the communities around us. And having worked so hard to build that name, everybody will want to protect that name, whether in or outside the organization. Similarly, organizations have their own brand image that they want to protect. As the employer of choice, as a champion of employee rights, and also as a good citizen who complies with all the legal requirements. But when there is non-compliance, either by a manager or an individual employee, then the reputation of the organization is likely to suffer. And that is the very reason we are here to conduct an HR audit to find out aspects that can make an organization to be vulnerable, which can expose them to legal disputes, financial penalties, or reputational damage. I want to move to the next slide, and these are the essential areas in HR compliance. There are quite a number. On this slide, I've projected 7. There are others that will follow after this slide. I want to start with the employment and the labor law compliance. In particular, the Employment Act. This is where we get to understand the various aspects that are related to employee-employer relations and the protections that they have when there is a violation. In the Employment Act, there are various provisions, including the employment contract. As I will mention, there are various types of contracts that employees can be given, whether it is full-time, part-time, casual, intern, or independent contract. These are contracts which must be fair. A fair contract has certain characteristics. One, there is a clear definition of roles and responsibilities. Clear definition of roles and responsibilities. This is contained in a job description, that when we engage people for any services, we give them contracts, and these contracts are accompanied by job descriptions. So the job descriptions must be fair for them to be enforceable in a contract. So fair contracts must have those clear roles and responsibilities, that the employees are expected to perform certain activities and be accountable for their outcomes or results. Another characteristic of a fair contract is that there are clear compensation, wages, and benefits that employees are entitled to. Compensation, benefits, and rewards. If the employer does not clearly state the amount of pay that the employee can receive at the end of a period of time, then that contract is said to be unfair. Why? Because the employer can take advantage of that silence to exploit the employee by underpaying them. So the Employment Act protects the employees by stipulating that the contracts must be fair. Another characteristic of a fair contract is that there are clear timelines for working, that is working hours, and also provisions for holidays and weekends. That a normal working day in the Kenyan environment is 8 hours. Any extra time that an employee works is treated as overtime. So employers should not extend beyond the stipulated number of hours. And if they do, they should pay the employees some overtime. So those are some of the characteristics of a fair contract. Speaking of wages, salaries, and benefits, we are saying that employees should be paid fair wages for a fair amount of work done, meaning that the wages we get should be commensurate to the tasks that we perform. This again goes back to exploitation, where employees get very little in return for the amount of effort they contribute to the organization. So wages must be fair, commensurate with the amount of effort that is put into the job. I've talked about the number of hours, which is 8 in the Kenyan standard. Any extension should be treated as overtime. Conditions of work have to do with almost everything that I've mentioned, including the health and safety conditions. That our environment in which we operate should be safe and should be healthy, free from illnesses and accidents. And there are quite a number of labor laws that regulate the health and safety of employees, starting with OSHA and then WIBA. So those conditions must be conducive for the employees. If the employees are exposed to dangerous working conditions, then they can resign and sue for constructive dismissal, meaning that the employer has created very difficult conditions that can make it impossible for him or her to work or function effectively. Lastly, on bullet 1, I've mentioned the legal employment practices. That all the employment practices must be legally protected, including hiring employees. One of the requirements in the Employment Act is that the person to be considered for hiring must be above 18. Anybody under 18 is employing a minor. Though in some cases, the Employment Act also says that minors can be engaged in family activities without the expectation of pay. That's an exclusion. So employment practices has to do with aspects to do with payment, aspects to do with hiring, aspects to do with training, aspects to do with compensation. These are all employment practices that are protected, including the right to join trade unions. Secondly, is the recruitment and the hiring practices. I have indicated that HR managers must apply fair, legal, documented, and transparent recruitment and selection procedures. I've talked about fairness. Fairness has to do with equal treatment of employees, irrespective of their background. So fairness must be practiced when we are hiring people. And one of the policies that we always quote is one that says that we are an equal opportunity employer. Equal opportunity employment gives fair opportunities to all eligible applicants to be hired. Then the recruitment and hiring process must be legal. In the Kenyan law, any alien who is seeking an employment below managerial level is committing an offense. Unless they are experts coming in at the top level and that expertise is not available here in Kenya. So it's a legal requirement to ensure that we employ only those people who are eligible. It's also a legal requirement that we don't discriminate against anyone, especially those who qualify, either on account of tribe, on account of ethnic background, or on account of physique, the physical outlook. Even those people who are abled differently have a right to be hired for as long as they have the qualifications. And then the other aspect is documentation. It is a legal requirement that any employment contract should be documented. How? An employee must get a copy of the employment letter, which is a document. And this same document should be kept in the employee's records. That in case there is a dispute, both the employer and the employee have a document to which they can refer so that they can make a decision. So documentation is very key when it comes to employment, starting with the employment contract. Another documented aspect is the employee's personal data, including the name, the ID number, the telephone, family for purposes of medical cover, and also bank accounts. This should be documented, and the employee should be informed of the need to document all this information. It is for administrative purposes, which is a legitimate reason. But anything that is not legitimate should not be documented. And then HR managers must demonstrate transparency in recruitment and selection. That the processes should be above board, and that the final person selected is the one who merits. And this requires that HR managers do several things. One, shortlist people in an open and transparent manner. Two, communicate, if need be, the reasons for not hiring a person, especially through a reject letter. But some organizations today do not want to incur expenses. What they do in the adverts is that they will indicate employees who do not receive any communication after 2 weeks or so should consider themselves unsuccessful. Although this is a cost-cutting strategy, but for some organizations, this is very important, that people have to know the reasons why their applications were rejected in the spirit of transparency. So another aspect of transparency is ensuring that the scores that employees get during recruitment and selection are based on objective criteria. And this depends on the weighting of the various aspects to be assessed. Dressing may not be a very important aspect for some organizations, though in others is very important. So the weighting will vary. Employers will put more weight on the skills, knowledge, and experience compared to the way a person is dressed. But if you are in an organization where dressing is very important, then more weight will be put on dressing. So recruitment or hiring practices must be fair, legal, documented, and transparent. And that ensures compliance. Thirdly is the aspect of employee classification. This is where we characterize or categorize employees based on their contracts. There are various types of contracts. One is permanent contract, where an employee works until they resign or retire. It lasts for a long time and employees are paid on a monthly basis. Then there is a short-term contract, which is part-time. For full-time, the number of hours is between 35 and 40 hours a week. For part-time, these are employees working for 20 hours or less. And their payment can be prorated depending on the agreed contract. So the second contract is part-time for employees who are working less than 20 hours. And then there are those casuals who work on a daily or a weekly basis. Their payment can also be done weekly or daily, or can be put together so that they are paid at the end of a month. But again, care should be taken to allow employees who are casuals to work for a period of 3 or 6 months, which means that their contract is automatically converted into permanent. So if they are casuals, let them be paid on a daily or a weekly basis. And if they are to be paid at the end of a month, it should not be more than 3 months, because the law says that that contract can be converted into permanent. So what happens at the end of that month? The contract ends and the employee has to be away from the work for another whole month before they come back. Fourthly is compensation and payroll. This is a very critical issue in the life of a HR manager, because employees work or put effort in return for compensation, unless somebody is willing to work for free, voluntary work. So if employees have been given a contract, whether permanent, casual, or part-time, they should be paid in the agreed manner. Most importantly is timely payment, that the employee should be paid at the end or completion of a task. That means that the payment should not delay for a long time, because that amounts to unfairness. So if it's your policy to pay on a timely basis, for example, between the 28th day or the 5th of the next month, let it be consistent. And again, this allows employees to plan themselves on how they are going to spend their money. So timely is fair, timely is also legal. Accurate payment is that employees should be paid the exact amount that they bargained for, or as is indicated in their contract. Meaning that as HR managers, we must do the right calculations for the number of days worked or any overtime that employees have dedicated to the organization. So they must be calculated so that the employees get their fair pay. On deductions, there are those statutory deductions, which have become too many today. For example, pay as you earn, 2, SHA, 3, housing levy, and probably union dues if some of the employees are unionizable. The union dues are deducted at source. And it's the responsibility of the employer to make sure that the dues are deducted unless they want to kill the union, which is an offense as well. So on compensation, it's a legal requirement that the payment is made on a timely basis, it is accurate, and that proper deductions have been made in compliance with the Employment Act in particular. On benefits and leave administration, it is an essential area in human resource management. Talking of benefits, like retirement benefits, or sick leave, or compassionate leave. These are benefits, although they are not regulated in law, but it's a fair practice. For some organizations, they give compassionate leave, especially for people who have been bereaved or their relatives are sick, up to 7 days. Others give up to 2 weeks so that they can give their employees enough time to mourn their beloved ones. Benefits like retirement benefits are regulated in law, and an employer who has more than 5 employees is required by law to register with the NSSF. NSSF is a statutory body to where contributions can be made to take care of those employees who retire. And therefore, HR managers are required by law to deduct those statutory benefits like retirement. Annual leave is a right of every employee. That after working for 1 year, an employee is entitled to at least 21 working days. Some organizations vary this. What they do is to give employees 2 weeks uninterrupted leave, and then the rest of the days can be staggered over the year. This works for them because whenever there's a lot of work to be done and there's pressure to ensure that customers are served, employees may be asked to stagger their annual leave over a period of time. But the minimum requirement, at least 14 days uninterrupted leave. On workplace safety, which I've mentioned, is that we have a right to be safe in our workplaces, safe from injuries and safe from illnesses. And as a compliance requirement, we must ensure that, 1, there is enough ventilation for our employees. 2, employees are given personal protective equipment if required. 3, employees are well spaced, at least 1 meter square between one workstation to the next. 4, there is adequate natural lighting. And 5, there is wholesome drinking water. In addition, as a requirement, the washrooms must be clearly separated for both men and women. Under very extreme circumstances is when you allow female and male employees to share. But the law requires that you have different ablution blocks or restrooms for both male and female employees. So annual leave is a requirement, and that all of us are entitled to this requirement. On equal employment opportunity and non-discrimination, and again we go to the Employment Act, which says that all employees in the Republic of Kenya have a right to non-discrimination when it comes to employment, be it a new post or posting or a promotion. They have a right to be promoted and not to be discriminated against. And in the spirit of this equal opportunity employment, we develop policies such as equal opportunity employment so that we don't discriminate people. Although in some cases, some employers may violate their own policy, which is unfair, it should always be borne in mind that discrimination may lead employees going to court, including employees who have not been hired. If they have evidence that they were discriminated against during the hiring process, they have a right to go to court and force the organization to hire them on account of discrimination. Another essential area or areas are this, that is employee records management. As a good practice, the records of employees should be kept current, that is up to date, safe, and protected from unauthorized access. There are many records that we keep about our employees. One, personal records related to the name, the family, health status, among others. Two, promotion. Three, training. Four, performance. Reports or records. All this should be kept in a secure and protected place. If we fail to protect this, then people can obtain this information and use them against the organization, even against the employees. As I have indicated earlier on, the Data Protection Act requires data controllers to ensure that there are adequate safety measures to protect personal data related to all employees. In addition, the Data Protection Act allows the employees to update or change any records that are contained in the record system. And they can do this at any time as long as there is adequate notice. So an employee can request for a change of a record after giving a notice. And again, your policies will say the duration of notice that can be given if an employee wants to update or change a record. Usually it's 7 days up to 14 days. While the notice to allow the employer make adequate preparations to avail the records. And two, to ensure that there is no unauthorized access to the records without adequate preparation. Only the records that is requested can be changed and no other. And then another area is disciplinary and grievance procedures. All our organizations have had instances of indiscipline. So employees can be indisciplined because of several things, which I don't want to go into. But the process of discipline must be fair and must be transparent and lawful. Part of the reason why employers lose cases in court is because of failure to follow due process. Even if it's a minor offense, due process must be followed. For a major offense, which is gross misconduct, due process must be followed. And this process must be documented in our code of conduct or in our policies. All policies, assumably or presumably, should be fair and lawful. For instance, the process of dismissing an employee should require that, one, the offense is reported and recorded. Two, investigations are done. Three, the affected employees are called to show cause. And if the show cause is not enough, they are called to a disciplinary interview. After the interview, and if there is enough reason for the employee to be punished, then a decision is made by a disciplinary committee. This disciplinary committee should be called by the HR manager. So that process is important, because if you skip any step, then an employee can go to court and seek redress. The other aspect is grievance procedure. Grievances are complaints. Complaints may relate to several things. One, working conditions. Two, deductions. Three, harassment. Four, workload. And five is performance management results or performance appraisal results. And there are many other complaints that people can raise. So complaints are part of the employment relationships, and everybody has a right to complain, whether you are a senior, mid-level manager, or junior employee. A good manager is one who takes action on the grievances or complaints that have been made. This action must be lawful, must be fair, and should be resolved within a short time. If there are many grievances that are left unresolved, they may become a major industrial dispute, which may ignite fires that the managers may not be able to put out. So it is a good practice for HR managers, once the grievances have been reported, they are investigated thoroughly and actions being taken. So both disciplinary and grievance procedures must be lawful, meaning that they follow the due process. Two, they must be fair. And three, action must be taken in a timely manner. Why do we talk of timely? Because justice delayed is justice denied. And that is a legal declaration that when it takes too long for somebody to get justice, especially in a grievance procedure, then it becomes unfair to that employee. Another area which is a compliance area is training and development. And one of the aspects that is regulated is mandatory training. What are the examples of mandatory training? One is health and safety, that employers are obligated to train their employees on a regular basis on health and safety, so that one, we reduce the number of accidents. Two, we create awareness of mitigating risks associated with accidents. Secondly, those of us who work in the public sector, it is a requirement that all employees be taken for training at least twice, if not once, twice in a year. It is not fair for some employees to be trained regularly and others are not taken for training. So it's a public service requirement that employees should be given an opportunity for training and development. I'm also aware that for professionals, some employers take their professional employees for training. For example, accountants, human resource managers, and engineers. And the employer meets the financial requirements of this training. And again, it's also a fair practice to promote access to learning, that all employees should be given equal opportunities to advance their skills and knowledge. Even if it's done internally, it is good to give opportunities for employees to acquire new skills and knowledge for two main reasons. One, for their personal professional development, and two, for HR managers, it's for career development as well as succession planning. Another regulated area is termination and exit, where termination refers to the end of a contract. And exit has to do with leaving the organization through various methods of termination. Termination can either be voluntary or involuntary. Voluntary termination is where an employee resigns or takes early retirement, which means that the employment contract comes to an end. Involuntary termination is initiated by the employer, especially when, one, there are no jobs to be done by the employees, which means that there is redundancy. Two, is disciplinary terminations, where employees are dismissed on account of indiscipline. Or three, mutual agreement, where both the employer and the employee agree to terminate the contract because of the existing conditions. I don't want to call death as a termination, but it's a way of ending a contract. And employers have a right to look for a replacement. Exit is the way people leave the organization. The exit process should be seamless, that if it is retirement, employees are exiting through retirement, the necessary preparation should be made for the employee's exit. If it is resignation, The exits should also be handled in a fair manner. But the emphasis on termination and exits is on one notice, that if an employee is leaving the organization through resignation, they should be given adequate notice, at least 1 month notice. The same to the employers. If the employer intends to terminate the contract of an employee, for example, through redundancy, they should give 1 month's notice and they should pay the notice period. Secondly, are the benefits that accrue to the employee after termination and exit. For example, any pending leave days should be tabulated and the employee paid their leave days as required by law. This benefit is not negotiable because it's a provision in law, particularly the Employment Act. There are other benefits like retirement benefits, where the employee should be given those benefits on time. Others like gratuity should also be paid. That these benefits should be paid ideally, and is a best practice before the employee exits the organization or immediately after exit. Because in some organizations, these terminal benefits are delayed even for as long as 5-10 years, and the employee suffers. We are not being socially responsible because that's unfair for an employee who has worked for you for such a long time and then suffers because you are holding their money. There is another aspect which is also regulated, that is the union relations and industrial compliance. The union relations are captured under the Labor Relations Act and the Labor Institutions Act. A union is an institution which can be sued and can sue. And that is why it is under the Labor Institutions Act. If there are any disputes, the union has a right to negotiate with the managers or employers to resolve their matters. Meaning that for a union to do negotiations which result in a collective bargaining agreement, they must be duly recognized. It's a requirement by law, especially the Labor Institutions Act, that employees have a right to create a union that will champion their rights. And once such a union comes into existence, it's the obligation of the employer to recognize that union. So as a legal requirement, HR managers are expected to respect the unions. How do they show respect? Allowing their representatives to negotiate on their behalf without fear or intimidation. 2, implementing the collective bargaining agreements. Once a CBA has been registered with the Employee and Labor Relations Court, it becomes binding to both the employer and the employee. So it's upon the employee and the employers to comply with the provisions of the CBA. Failure to implement might lead to industrial action, such as 1, a strike, 2, a go slow, or 3, picketing. All these industrial action affect labor relations in organizations. So it's upon the managers to implement the CBAs that have been agreed with their unions. And lastly, we are obligated to comply with the labor laws without exception. Some employers obey or adhere to the labor laws as and when they feel convenient. All laws must be adhered to without exception. The other protected area or an area of compliance is corruption and ethics. Corruption is a criminal offense under our laws, including the Constitution. Anybody who engages in corrupt practices should be prosecuted under the law. Corruption is a vice that affects both private and public entities, and they deny people their rights or services. So corruption basically is about stealing. And corruption can come in many forms, as early as recruitment and selection. That for a person to get a job, they must part with money. Yesterday in our circle, somebody mentioned to us that there are letters that are being dished around by politicians for employment in various public institutions, including TSE. This is corruption. Anybody who qualifies to be employed has a right to apply and get a job. But because of corruption, we are denying opportunities for people who qualify. In training, there could also be corruption, that only those who are close, the training managers or HR managers, are given training opportunities. That unless you are close to them or you are friends, is a form of nepotism. You are given an opportunity to be trained. And some get many trainings, as many as 5 in a year. That is corruption. Corruption can also come about when we are promoting people. The best practice is that only those people who qualify or have potential are to be promoted, and there is no shortcut to it. If somebody corruptly obtains a higher position, you are denying an eligible employee that senior position, and that can eventually affect the organization. Because the moment a person is corruptly promoted, then their performance is not likely to meet the expectations, and the organization will be dying slowly and surely. So what do we do as HR managers to ensure that we fight corruption and ensure ethical compliance? One is to promote ethics. Ethics has to do with adherence to the moral standards that are acceptable in organizations and society, as well as the law. Secondly, we prevent favoritism by ensuring that only people who qualify are promoted or hired or are trained. And we also need to protect our employees at all times so that we ensure ethical compliance. And we know that ethical organizations promote professionalism, enhance their corporate brand, and also promote their reputation. Lastly is the element of diversity, equity, and inclusion. Diversity, as I indicated earlier, is celebration and employment of people from different backgrounds. Equity is about fairness. Inclusion is that people are involved in key decision-making processes. For example, in the public sector, no major decisions can be made both at the county and the national levels of government without public participation. So the public must be included in the decision-making processes, whether it is an infrastructure project or procurement of capital facilities, capital-intensive facilities. So public participation is important. This helps to ensure fairness, equal opportunity employment, and inclusive representation. So that everybody has a share of what is going on in the organization and that they benefit. So ladies and gentlemen, these are the key areas that are regulated or essential in HR compliance. These areas are not limited to the ones that I've given, but there are quite a number of others. So to that point, I want to invite any questions or comments so that we can move to the next part. On my screen, I can see Adan Siad. Adan, if you are there, any question or comment? Okay, Christine. Christine is not around or has no comment. Caroline Nzioka. Anne Sangira, if you are there. Okay, apparently there's nobody who has a question or a comment to make. And therefore, I will move to the next slide. And that is benefits and compensation, which I've already indicated that we must be careful on the statutory deductions and the accuracy of payment and benefits. Discrimination and others, I think I've mentioned that. What is the importance of compliance? How do we benefit by complying with the labor laws, policies, as well as industry standards? The first one there is legal protection. That when we comply, nobody can go to a court of law and sue us, which means that we will be protecting ourselves from lawsuits, fines, and penalties. And that can only happen if we comply. We have the legal protection. When it comes to recruitment and selection, nobody can go to court to sue us because of violation of a law, in a labor law. Or nobody can go to court on account of unfair dismissal. Or nobody can go to court on account of data protection. So all these lawsuits, fines, and penalties can be avoided if we comply with the law, the policies, and the industry standards. Secondly, we promote organizational integrity by complying. I have just mentioned ethical behavior, where people behave in a manner that is acceptable to the organization and the society, and also to their profession. As HR manager, we are all governed by our regulator, that is IHRM. Anybody who behaves otherwise risks being penalized or even being struck out from the professional practice. So integrity is very important when you comply with the law. I guess you are all aware that as a result of the order that was given by the Minister of Interior, the Law Society of Kenya has petitioned the disciplinary board of the Law Society to strike him out of the register because of integrity issues. So we don't want to risk being struck out of this register and then we are exposed or we become vulnerable. So when we promote compliance, meaning that we adhere to the laws and to the policies that govern employment relationship, we are safe. So we promote integrity. Risk reduction, we mentioned, or I will mention employees cannot go to court to sue the organization for failure to comply with certain legal provisions. So we reduce the risk of lawsuits, fines, or penalties. Others could be operational risks, which are day-to-day activities, or reputation, which is the name of the organization. When we don't comply, it means that is impunity, and we dent the reputation of our organization. We also promote employee trust, that we build confidence in our managers when they comply with all the laws and policies. And that requires that at the individual level, we treat all employees fairly. Fair recruitment, fair training, fair promotion, fair appraisals, and fair disciplinary. And all this fairness is consistent with the labor laws. On business continuity, that if we comply, we don't risk being interrupted or even being closed for non-compliance. For example, an organization making food products must ensure high levels or standards of health or cleanliness. If the city council or any other institution charged with quality assurance comes around and finds a very dirty place, that organization risks closure. But if we comply with all the health standards, including the employment laws, then we reduce the possibility of being interrupted because of unfair practices. So those are some of the reasons why we should comply with the law. Others include reputation management, where we protect our name and promote a positive public image. And we promote the employer brand, that if we are known for fair practices, then we are likely to attract quality employees as well as quality investors. Another aspect which is related to the importance of compliance is audit preparedness. Both public and private entities are audited on a regular basis, either by internal auditors or external auditors. When we conduct a HR audit, particularly on compliance, we prepare ourselves for the formal audits, which are conducted by internal auditors or external. So through this audit, HR audit, we keep all the records up to date. All policies are updated and compliant. and all systems become ready for this exercise of auditing. So if you want to prepare for the internal and external audit, start with the internal audit, particularly compliance audit. That does not mean that we should forget functional audit. We should. Tomorrow we should be talking about functional audit, where we'll be looking at the various parameters related to the various functions as HR managers. The other benefit is workplace safety, that we guarantee or we assure our employees that they are safe and secure, that they are not likely to be sick or get into accidents because of preventable things that we can take. Talent retention, where does it come in? In recruitment, in training, and in succession planning. That if we comply with our own policies, we retain those highly talented employees, which means that our policies and practices must be fair, equitable, and transparent. For example, when it comes to promotion, only those who merit should be promoted. And these are people with potential. So what must they have for them to be promoted? 1, skills. 2, knowledge. 3, experience. And 4, abilities. These are the employees eligible for promotion and no other person. So when we adhere to our own policies on promotion, then we are likely to retain our staff. And lastly, when we comply with the law and our own policies, we ensure strategic alignment, meaning that the policies, practices, and the systems support the attainment of strategic objectives. And the strategic objectives might be relating to 1, customers, meaning that you increase your market share. 2, revenue generation, meaning that you generate more profit. 3, business growth, that we are likely to grow our businesses to become competitive in the market. So when we do things right in a fair and a legal way, we are aligning ourselves to the strategies of an organization. I have been discussing the concept of compliance. Our title is Compliance and Risk Management. Compliance and risk management. Now we turn our attention to risk management, starting with risk itself. I have defined risk as an issue that has a potential of causing failure or even interruption to the operations of an organization. There are many risks, which I will again mention as we come to a close of this program this afternoon. 1 is legal penalties. That is a risk. I've said that an organization can be fined for not complying with the law, or financial loss, where money is lost because we have not complied with our policies or have not complied with the law. Reputation, the image of an organization is dented or damaged because of people behaving in an ethical manner. And lastly, risks are those that are associated with operational inefficiency. where one, we take a long time to produce a service or a product. Two, we spend a lot of money to produce that product. Or three, we discourage our customers because we have taken a long time to serve them. So this is operational inefficiency. This affects an organization, and this is what we want to take care of by conducting HR audits, particularly related to risks. There are many risks related to all the functions of HR, starting with recruitment. If you recruit a wrong person, you are likely to expose your organization because these people are not going to perform the expected standards. Or you don't train your employees. That means they remain with the old skills which are not applicable in the modern organization. Or if it is performance management, we do not set clear and objective targets, and employees fail to achieve them, and then organization loses. Or it could be compensation. We don't compensate our employees fairly and competitively. What is the risk? Employees don't perform because of lack of motivation, or they exit the organization, and that is turnover. Turnover is expensive because we know the amount of time it takes to find a suitable replacement and the amount of money that is spent to hire a new person. So many of our functions have risks, and we should be able to identify the risks early enough and take mitigation measures to reduce their impact. Ladies and gentlemen, we want to move to the next one, types of risks. I've given a number of them there. One is compliance risk. If you look at my meter gauge, it can be low, medium, or high, depending on the nature of the violation. So when you violate any law, it becomes a risk. Why is it a risk? Because of the attendant fines and penalties. We don't want to incur these unnecessary costs if we can prevent them by conducting these HR audits and identifying weak points and gaps and taking corrective actions. So compliance risk has to do with the violation of the labor laws and regulations, such as fines and penalties. Secondly is operational risk, where we are saying that the day-to-day activities of an organization can be hampered, which can directly affect productivity and service delivery. So what could be an example of an operational risk? One could be allowing employees to come to work at any time they wish, meaning that they can report anytime from 8 to 11. If the code of conduct requires that employees report at 8, then we will be in violation of that requirement because it will affect service delivery. Or if it is flexi methods of working, where employees are allowed to come at an agreed time between 8 and 10. Those who report at 8 leave at 3. Those who report at 9 leave at 4. And those who report at 10 leave at 5. Why do we allow this time? To enable employees perform their chores so that they can report to work at a time that is convenient to the employer and the employee. But if we allow people to report to work after 11, meaning somebody can report at 1 or at 2, knowing well that most people go to organizations for services between 10 and 3. These are the peak periods of most organizations. So it becomes an operational risk, allowing employees to report to work at a time that affects the operations of an organization. And service delivery can be hampered. Customers can be very unhappy. And the bottom line cannot be met. The other type of risk is strategic, where HR policies, practices, and strategies are not aligned with the corporate objectives. If there are weaknesses or gaps in the HR department, that can affect the attainment of overall organizational success. So as we audit this department, we should also look at the risks in terms of strategy, that an organization may not achieve its strategies because of an aspect in human resource like recruitment and selection. And how can that happen? We hire the wrong people to do the right jobs. For us to ensure that we have the right people doing the right things in the right way at the right place and time, we should have a working human resource plan. This shows us the direction in terms of new hires, if there are deficits, reductions in our manpower if there are surpluses, or retention strategies to ensure that employees don't leave the organization. So a strategic risk is where an organization does not achieve its strategic objectives because of misalignment between HR function and corporate strategy. The other risk is reputational risk. This has to do with the negative image of an organization resulting from poor decisions made by HR managers or employee behavior. If employees don't behave in a manner that is acceptable, that reflects on the integrity of the organization. Or if it is training and development, we only train our friends and relatives. That reflects on the image of the organization. Or it comes to compensation. Our compensation system is not internally equitable and externally competitive. That becomes a reputational risk because no potential employee can touch an organization which does not pay their employees fairly and competitively. The last one is financial risk, where organizations lose their money because of unfair policies, practices, and systems which we are auditing. So these costs relate to recruitment, For example, we use manual methods to recruit people. That becomes a loss because there's a lot of money and time spent. Or training. We don't conduct training in this analysis, and we end up training the wrong people. And that is a financial risk. Or having a bloated workforce, meaning that we have too many employees doing duplicated work. That becomes a financial risk because there is money involved. So for us to ensure that we avoid these financial risks, one, we must adhere to the labor laws. Two, formulate clear and fair policies. And three, treat people in a fair and equitable manner. So those are some of the risks arising from the operations of HR. Other risks include talent management risk, where we are losing our employees either to the competition or others starting their own business because they don't want to experience the same. So in talent management, we are talking about attracting, utilizing, and retaining those high quality staff. So talent is key. And if we want to be successful, we must ensure that we hire the right people, retain the right people, and utilize them in the right way. On workplace safety and risk, that is a risk where employees operate in an unsafe environment where there are many accidents or illnesses. If accidents are caused by situations in an organization, then an employee is obligated to pay compensation to the affected employees because they may not be able to work effectively after the accident. For instance, the loss of a thumb, which is one of the most expensive fingers that we have. So if an employee loses a thumb, that's very expensive, leave alone a limb like a hand or a leg. So we must ensure that our workplaces are safe because of the risks associated with health and safety in terms of compensation or even loss of an employee. An employee can die in the course of duty, either because of negligence or because of failure to follow the policies or the labor laws as provided by Employment Act, Labor Relations Act, as well as WIBA and OSHA. Technology and data risk is another risk that we should take care of. I have already indicated data protection, that personal data should be protected at all times. Anybody breaching this data is liable to a fine or a penalty. I said that an administrative breach of data may cost an organization 5 million or 1% of the annual collections. Or if it is a criminal where a data controller gives private data to somebody else, that's a criminal offense. Or using data for other purposes other than employment, the employer can pay 3 million or 10 years imprisonment. So data is very sensitive. we need to protect it at all costs. The risks are high, especially with the fines and even imprisonment. 10 years is a long time. The second last risk is employee relations risk, where there are conflicts between the employer and the employees. There are certain risks that arise from there. One of which I've mentioned there is disruption of work. Work comes to an end or is stopped temporarily. Under what circumstances can this stop? Industrial action. Industrial action can be initiated or instigated by the employer or the employee. On the employee side, there are three disruptions. One, go slow. Two, sit in. And three, picketing. In all these instances, work is disrupted. And that's what they call a strike. A strike can take any of those three forms, especially when employees are dissatisfied with the way they are treated or their working conditions. On the employer's side, the industrial action is lockout. The employers keep away the employees who are striking, meaning that they prevent them from coming to the organization. That is a disruption. Some of us have had experiences of strikes where employees are locked out. So when the employers lock employees out, it means work stops, their customers suffer, and there is a risk of losing business. So if there are poor employee-employer relations, that becomes a risk. And through the HR audit, we are able to identify these risks and take proactive measures to prevent conflicts. Lastly is the risk associated with succession planning, which means that we do not have employees who are adequately prepared to take over senior positions. That means that our succession pipeline gets dried up, that there is nobody who can succeed those who exit. And when this comes to an organization, it becomes a risk because there is no continuity. So lack of adequate talent planning, especially in terms of training, delegation, and mentorship or coaching, then we run the risk of having our succession pipeline drying up. We must have a continuous flow of people who are adequately prepared to take over senior positions. So those are the risks that are associated with HR. And if there is anybody who has a question, the floor is yours. Please ask or make your comment. From my list, I can see Adan, sorry. Adan, if you are there, you can make your comment. Karen Chepkirui, any comment or comment, question? Yes, Anne, go on.
Hello, good afternoon.
Sorry, I can't hear you. Hello, Anne.
Can you hear me?
Yes, I can hear you now. make your comment or ask your question?
Okay, I just needed to ask a question
Yes, I've lost you again.
from the previous slide that you're talking about union.
Yes.
In your question, yeah.
So you have a question or a comment?
It was just to ask what happens if you have an employer who doesn't want a trade union in the organization?
Allow me to answer it in two ways.
Okay.
One, that employer is in violation of the Employment Act, which gives employees the right to join a trade union of their choice. And such violation can lead to a lawsuit, and the employer can be compelled to recognize the trade union. In some organizations, there is a mutual agreement between the employer and the employee that they do not have trade unions. So if there is such an agreement, which is mutual in nature, then there could be no trade union. But if there is a trade union, whether internal or external, that the employees may want to join, then the best thing to do for the employer is to recognize the union and also enter into a collective bargaining agreement. Otherwise, the employees might go to court and seek redress. So, Anne?
Thank you.
Asante sana. Anybody else with another question?
Okay, Mr. Andrew, I have a question.
Yes, Judy?
On the risks, on the types of HR risks, where does culture, like having a bad culture, lie when it comes to, because I believe it's also one of very big risks that we have in the HR. Most of the companies are struggling with the culture because sometimes it's really, you may have even the right kind of candidates, but when they find the culture that is there in the organization, it leads them to be unproductive. So where do we place the culture and how do we handle it?
Thank you, Judy. Allow me to answer your question in two ways. One is that there are the types of HR audits that we mentioned earlier on, one of which is cultural audit. And in cultural audit, we are looking at the values, the practices, and the belief system of an organization. So the question we ask ourselves, do those values and practices promote the attainment of corporate objectives? Or two, do they enable us as HR departments to function effectively? So for you to be safe, even when it comes to recruitment and selection, where new employees find a culture that is not conducive, that can be corrected by conducting a cultural audit. So that is one way of doing that. You conduct a cultural audit specifically to identify the values and practices that may affect all the functions of an organization, be they recruitment, training, performance management, or employee relations. So culture cuts across. Secondly, when you talk about risks, all these risks, whether compliance risk, operational risk, strategic, touch on culture. And like I might have mentioned earlier on, that a poor culture may have strategy for breakfast. That means culture eats strategy for breakfast. If you have a poor culture which is rigid, which does not promote the core values of the organization, then we expose ourselves to all these types of risks. Compliance is one of them. If you don't value the law, that is impunity. That's a culture of impunity. Two, if you don't value employee confidentiality, then that becomes a data protection risk where you are exposing the private information of employees to others. And that is a cultural issue. The other one is reputation. Reputation comes from all those core values like honesty and integrity, as well as customer care, whether internal or external, and professionalism. If these values, which are cultural in nature, are missing or are lacking, then we earn ourselves a negative reputation or image. The same with financial risk. If our culture does not value prudence in our expenditure, and I'm sure all of us have heard this statement said by people that hii ni mali ya serikali. So the moment you have that mindset, even if it costs the organization a fortune, you don't care because ni mali ya serikali. That's a cultural and perception issue that, like I had in some quarters, bahari haikauki. That government is like the ocean. It never gets dry. So it has all the money to be stolen. And that reflects on the reputation and financial risk. So basically, you can talk about that our culture should be such that we promote the values at all times to avoid compliance risks, operational risks, reputational risks, and other risks that we have mentioned at the end of that slide. That is succession planning. So if culture is tailored in a way that it is fair, it promotes professionalism, promotes integrity and honesty, all these risks will disappear. So Judy, have I answered your question?
Yes, you have. Thank you.
You are welcome. Thank you very much. I now want to move to the next slide. What are the strategies of identifying risks? There are many, and I don't want to limit myself to the 6 that I have given, but nevertheless, allow me to explain them one by one. The first one there is policy and procedure audits. That at the beginning of this presentation, we said that we are going to audit 3 key things. 1, policies. 2, practices. And 3, systems. Policies is one of the area which we are auditing. And we audit these policies to ensure they are in compliance with the labor laws and that they are up to date. The moment we have policies that are outdated, then they may not be in compliance with the labor laws. And that is the reason why we conduct regular audits to ensure that we identify risks associated with operations, with finances, with strategy, and even reputation. Because when you apply outdated policies, it reflects negatively on your image, that you are not up to date. can imagine somebody quoting a section of the Employment Act using Cap 226. Replaced by the Employment Act. So anybody quoting such an outdated policy runs the risk of compliance, risk and as well as reputation. In all honesty, how can somebody quote such a policy or a law like Cap 226, which came to an end, which was repealed in 2007? So we should update our policies to reflect the current realities in terms of the labor laws. Secondly, is ensuring legal compliance by way of checking the labor laws on a regular basis. So who are the people responsible for checking compliance? One is the legal office. Organizations that are large enough have legal officers, and they have the legal department. And this legal department is in charge of data protection, as well as monitoring the changes in the legal environment related to employment. Secondly, in the absence of a legal department, is the HR manager or HR department. We should always be on the lookout of the changes in our labor laws, either by having a network in the government printers so that we can get all the legal documents related to employment, because government printers is where all the laws, whether environmental or labor related, are printed and stored. And we can get a copy from there. If not, we can have a research team to conduct research on the recent labor laws. So those are the three ways in which we can ensure compliance check. One, by having a legal department to be doing the legal checks. Two, the HR department by creating networks in the industry. And three, having a research department. So by complying, we ensure that we identify risks related to non-compliance. Employee file audit. We know that employees come and go. Their status changes, including marital. We should audit all these files to ensure that we have accurate and current data in our files. You can imagine an employee who left 1 year ago, and suddenly you realize that they have been utilizing your health policy. Who pays for that cost? The HR manager will have a hard time to explain if such a thing happens, that an employee has been utilizing the health or medical cover 2 years down the line after leaving the organization, which means that your systems, including filing system, is at question. So as a requirement, we must ensure that the files are complete and up to date. There should be no information that is lacking. If there is lacking information, that becomes a gap which the HR audit can identify. The other strategy is stakeholder engagement, both internal and external. Employees can help us to uncover those concerns. For example, we have said health and safety risks. As HR managers, we cannot be everywhere. Even if we have health and safety committees who conduct health and safety audits, they may not get everything that happens in an organization, especially if the organization is large. So the stakeholders like employees can be used to identify issues related to compliance, and we can capture these concerns, investigate them, and ensure that they are captured in our policy, or corrective action is done where there is no policy required. The other strategy is HR metrics analysis. Metrics has to do with measurements using either qualitative or quantitative measures. For example, turnover. We can identify the turnover rate through HR audits. How many people have left in the last 1 year? And how does that affect the organization? So a metric like turnover rate can be used to spot or identify warning signs and corrective actions be taken. The other strategy is payroll and benefits review. As a best practice, HR managers can, on a regular basis, review their compensation and benefits or rewards. This can be done by conducting surveys within and outside. Within, you identify the level of satisfaction, and externally, you conduct a survey to identify or establish the competitiveness of our compensation and the benefits. So by reviewing payrolls, especially in an environment like ours where the cost of living has changed, our employees might be suffering quietly. So we can review the payroll with a view to improving their compensation so that they are able to manage the growing standards of living. And we all know that poor payment has implications on the mental health of our employees. If the payment is so little that the employees are not able to meet their basic needs, then mental health sets in. Some may not call it mental health because somebody might think, hawa ni wazimu. We don't want to talk about wazimu hapa, but we can also talk about mental well-being. So we replace mental health with mental well-being, which is associated with the payroll. The deductions that we make, the salary reviews that we conduct, all affect the payroll. The benefits like medical benefits are also important because employees, especially in an economic environment like ours, may not afford high medical bills. So in that way, we are able to identify risks associated with retention of employees, which is talent-related risk, health and safety, as well as leadership development. Another strategy is the adoption of technology in conducting HR audits. Technologies like AI, cloud computing, as well as knowledge repositories like learning management systems, all help to discover vulnerabilities. As I indicated, vulnerability relates to exposure of an organization to a risk. So if we are vulnerable, it may relate to non-compliance, which makes us vulnerable. Or it could be outdated policies and records. So through adoption of technology, we are able to discover those vulnerabilities. AI, for example, can be used to manage our records. Any outdated record, which could be over 5 years, the AI can bring it to the attention of the managers by either sending an SMS or showing a red flag that this policy has not been reviewed for a long time. That's an intelligent system in our technology to discover those gaps. And for security, we can also have security systems in relation to data, that anybody who touches our data bases, an SMS can be triggered and sent to several authorities. One, ICT manager. Two, HR manager. Three, internal auditor. Or four, the CEO. That if our data management system is well secured, anybody who touches the system, an SMS is triggered. So that makes our data security safe and in compliance with the Data Protection Act. Benchmarking is another practice to identify those risks where we are comparing ourselves either within or outside. For example, HR can compare itself with finance or ICT. What are these best practices that they have embraced, which can protect, for example, data or ensure seamless operations? We can also do external benchmarks with other organizations in similar industries. For example, in telecommunication industry, Safaricom, Airtel, and Telecom can compare notes and find out what are the best practices related to human resources. In this way, we are able to remain competitive by way of borrowing those best practices. Another strategy is training assessment, where we identify training gaps through training needs analysis. As we said, HR audits help us to identify three key things. One, weaknesses. Two, strengths. And three, gaps. So gaps in training can be identified through training needs analysis. And as we said, that there are certain legal requirements related to training. For example, health and safety training as a legal requirement, or a regularity of training, that employees should be trained at least twice a year in all public entities. So when we do a training analysis, we are able to identify how many people have attended which trainings and what are the gaps that exist. Exit interviews are intended to identify challenges and gaps in our system, be they related to working conditions, to compensation and benefits, or to employee relations. That's why employees are leaving. So by conducting exit interview, we identify risks associated to those areas like health and safety, compensation, training, recruitment, and performance management. Whistleblowing has become a very important aspect, especially when reporting a wrongdoing. So whistleblowers are those people who report a wrongdoing such as corruption, embezzlement of funds, disposing of waste in non-designated areas, or any other unfair practices like harassment and unfair promotions. So whistleblowing should be embraced and allow people to report anonymously to the relevant authorities. So in this way, we are going to identify risks. We said that there are many areas of risk, such as compliance risk, strategic risk, or employee talent management risk. So when there is a whistleblower somewhere in our organization, they should not become targets of revenge, but as a source of information that can be used to protect ourselves when it comes to the risks related to compliance. How do HR managers manage risk? These are the risk management strategies which we set out to achieve in the topics that we mentioned. One is that we develop and enforce clear HR policies, and there are no two ways about this. Policies must be clear. They should not be ambiguous. They should be well defined and understandable by the users. Once the policies are clear, then we can manage all the risks, whether it is compliance risk, health and safety risks, or employee exits. Secondly, HR managers should ensure legal and regulatory compliance by following the law to the letter. Laws are there to guide us and not to prevent us from moving forward. So we should comply with the law. Judy might have asked, what do you do with the managers who do not want to allow employees to join a trade union? This is a requirement by the Employment Act. Employees have a right to join trade unions of their choice. That's a legal and a compliance risk. If we allow the employees to join the unions, we are complying with the law. We are not committing any offense. And what remains of us when employees join trade unions, we should not see them as adversaries or enemies. We should see them as compatriots and partners with whom we can work to improve our organization. Trade unions are not necessarily there to cause disruptions. It depends on how we manage them. Thirdly, is we implement strong recruitment and onboarding processes. Many of the mistakes that we see in relation to compliance start with recruitment and selection. That if this is not done well, we end up with the wrong people, which affects our operational risks. Two, if the employees are not onboarded well, it means that they are not aware of the policies, the culture of the organization, as well as SOPs. They are likely to make mistakes. And that can give rise to those risks that we have mentioned. Fourthly, HR managers promote healthy and safe work environments by ensuring that any accident-causing elements are removed and any disease-causing elements are reduced. So a healthy and safe environment is one which is free from accidents and free from illnesses. They should also encourage wellness. This is physical, emotional, and mental health. Physical by way of allowing people to engage in sports activities. Mental health by encouraging counseling and team working. Emotional by enabling people to work together or establishing what they call buddy system. If you have a buddy system, you will never go wrong because the buddies know where each of their members are and are able to tell what is going on. So if you have a buddy system, you are able to identify who is absent through the buddies. You are able to know what is going on if they are absent or what they are going through. So buddy systems are important as part of the wellness programs. The other way in which to manage risks is to establish effective performance management systems where we set clear goals, targets, and timelines. If the goals are broad and not clear, it becomes very hard to achieve them. Or if the targets are not measurable in the form of KPIs, and again, it becomes difficult to improve our performance management system. And lastly, we should be able to strengthen our internal control and confidentiality systems. Our Data Protection Act requires that we secure our data, restrict access, and protect the privacy of all employees, irrespective of their position. This will help us to avoid any penalties related to data protection. So we secure our data by installing firewalls or antiviruses, which help to protect our data. Restricting access means that we give authority to people depending on their position. So levels of authority in terms of access helps to prevent unauthorized access. And then privacy related to personal data must be kept at all times. This private data or information should not be given to third parties. The only instance where third parties can get information about the employees is when they are under investigation by a legal entity, such as the police. And even the police cannot come into organization and demand information about a particular employee without a court order. They must pass through the court to ensure that the information that we are giving out is given to the right people, basically the police or investigative agencies. Nobody else should be given this information except with express authority of the data subject. The data subject is the employee. What else can managers do is to train and educate their employees to be aware of the legal requirements, to be aware of the health and safety, and also to be aware of their rights and obligations. The other thing managers can do is to proactively manage their employee relations. How? By way of effective communication, resolving conflicts in time, which helps to build trust. Another one is to monitor and mitigate discrimination and harassment. As we have indicated before, monitoring should not stop. It is a continuous process. We monitor recruitment. We monitor training. We monitor compensation. We monitor health and safety. We monitor employee relations so that we identify any aspects that are not complying with the labor laws, with the policies, or industry standards. The other action that can be taken by HR managers to minimize risks is to ensure that there is an effective and workable human resource plan. From this human resource plan, we are able to, one, identify gaps in our staff establishments. Two, identify gaps in training and development. Three, identify gaps in succession planning. And four, identify gaps in career development. So a human resource plan is very important because we should be monitoring it as well to identify where we are with respect to those plans, whether it's a recruitment and selection plan, training and development plan, career development plan, or succession plan. In this way, we are not going to run the risk of having employees leaving the organization without adequate successors, or two, leadership gaps where we have inadequate employees to succeed others. And then lastly, we can leverage technology in order to track, analyze, and take corrective measures in relation to all the functions that we perform as HR managers. So those are the steps that HR managers can take in order to manage risks related to the human resource function. Therefore, we want to look at now the risk management tools, albeit in a quick way, so that we know what are these tools that we can use to identify or assess risks. One, we must have a compliance checklist. We look at all the labor laws and develop a checklist on what is required on the side of the employer and tick the boxes where compliance has been adhered to. SWOT analysis is another tool where we are scanning our internal and external environment. The internal environment will identify strengths and weaknesses, especially in relation to HR policies, procedures, and systems. External analysis will give us opportunities and threats. And this external analysis focuses on the labor laws, which are external, technology, which is also external, and the society, which is also external. How are we relating with our partners or even the communities around which we operate? Then gap analysis is another tool where we identify gaps, be they in recruitment, in training, in performance management, whereby we are comparing the HR department with other departments. That is what we call cross-functional benchmarks, or two external benchmarks. Risk heat maps. This is where we prioritize the risks depending on the impact that they have on the organization and the likelihood. So a risk can be likely or unlikely, and we can weigh this likelihood, whether it is high, medium, or low. If the likelihood is high and the impact is high, then immediate action should be taken. If the likelihood is low and the impact is low, we can do two things. One, monitor the situation, or two, ignore. But I will not advise anybody to ignore, because whatever looks small might convolute into something major, and that can be a cause of alarm in an organization. We can also use policy and procedure review checklists, especially when we are reviewing our policies on a regular basis. Our policies are usually reviewed after every 3 or 4 years. So we have a checklist of what to look for in these policies, whether it is a recruitment policy, a training policy, appraisal policy, or health and safety policy. So through this checklist, we are going to identify completeness, accuracy, and regulatory alignment, which means compliance. HR metrics are also other tools that can be used to identify risks. that these are data-based tools where we use dashboards or any other technological tools. An example is an LMS, which is a digital tool that can help us to track employee performance when it comes to training and development. LMSs are there to track training and development. How many employees have completed certain programs, how many have downloaded certain policies and procedures, or how many certifications that they have. The other tool is employee survey and feedback tools. I mentioned this when we are conducting salary surveys. Audit trail, where we are keeping records of all audits. We can get the status of where we are in terms of our audit, which activities are beginning, which are ongoing, which have been successfully completed. The second last is human resource planning and scenario analysis. We try to project into the future to identify potential gaps in terms of training, in terms of numbers of people, or in terms of technology. And lastly, we have legal and regulatory risk matrices where we are looking at all the laws, all the labor laws that govern the employment relationship. And we try to compare that with what we have currently in our organizations. So on that note, we come to the end of our presentation. And now I will invite all of us to ask any question or comment they may have before we close. So again, in no particular order, I can ask Emmanuel to make a comment if you are there, or ask a question. Jonathan?
Yes.
Yes, Jonathan, I can't hear you. Your network is a bit shaky.
Speak a lot of things. Can you hear me? Yes.
Hello, Jonathan.
Hello.
Yes, can you ask your question or make a comment?
Can you hear me?
Yes, I can now hear you.
Let me. I just want
Yes.
to make a comment. I just want to make a comment. Really been important for me. I've learned and picked a lot of things, especially when it comes to compliance and being able to mitigate the risk. One of the things is the metrics, where we are able now to understand the effects of having a running audit to ensure that we comply with the risk that might come in the organization. So that's my comment. I'm very grateful. Thank you.
Thank you very much, Jonathan. Yes, we need to use those matrices to identify risks and take action to ensure that we avoid them. So thank you very much, Jonathan. Anybody else with a comment or a question?
Yes, Sandro.
Yes, sir. Go on,
Adam
make your
Siak
comment.
here.
Yes,
I think
Adam.
thank you so much for this presentation.
Yes.
It is long overdue for some of us.
Yes.
I think one of the general comment I would like to make is that it is very essential that HR policies and procedures remain fully aligned with the local labor law,
Yes.
data protection regulation, and donor compliance requirement for those non-profit organizations.
Yes.
So the other thing is the recruitment process must demonstrate, of course, fairness, transparency, and non-discrimination, as you said, with a proper documentation maintained to support the audit readiness.
Yes.
The other stuff that I would like to talk about, document and record keeping, is that there's a need for a centralized and secure HR report management system to ensure data privacy and essential retrieval for audit purpose. And then my last bit is a bit on issues of headhunting. I know maybe it may come on the next meeting, next training tomorrow, but I wanted to know in terms of audit or compliance related to policy on headhunting. Thank you. Over to you, Mr. Andrew.
Thank you, Adan, for your comments. I'm delighted that you have several takeaways in relation to data protection, in relation to recruitment and selection, and other areas. Thank you very much. On headhunting, this is a subject that we can discuss probably tomorrow when we are talking about the functional audit. Headhunting falls under recruitment and selection. That when we are headhunting, we should not violate the law, and we should not violate our own policies or industry standards. So if we have to headhunt, we are looking at what does the policy say in relation to the employee that we are headhunting. Is it provided for in our policy? Usually headhunting is done for senior management. Why? Because we want them to replicate their performance and experience in our organizations. So there's nothing wrong with headhunting a person for as long as, one, you are able to pay them, two, you are able to retain these people, because even if you headhunt, somebody else is also headhunting them, and three, that this payment is sustainable even when you are headhunting. So you have to look at several factors. One, compliance with the law. Two, sustainability. And three, that the employee is retained, retention. So we shall look at that. What are the risks, for example, of headhunting? One of which is that there's no guarantee that this person will stay in your organization forever. And it becomes expensive as well. To headhunt means that you must pay above the industry rates. And that's where we talk of sustainability. So we must ensure that there are those adequate practices, that if we headhunt, it means that we don't have suitable replacement from within. And awareness must be created among the existing managers that we are headhunting, not that we are ignoring them. Especially in public sector, management level 3 or 4 is open to competitive recruitment, and therefore headhunting should not be an issue, because in any case it's open to competitive recruitment. So thank you very much, Adam, for your comments and for your question. Anybody else with a comment or a question before we close?
Mr. Andrew, I also put some few comments on the chat box. Thank you.
Oh, thank you. Asante sana. I want to take this opportunity to thank all of you for finding time to be with us this afternoon. I believe that this has been an informative and insightful discussion. I look forward to seeing you again tomorrow at 8:30 at the same place. Thank you, and God bless you. Have a good evening.
Thank you to all.